I still feel like I'm in the beginning stages of like really getting myself initiated into this case. I've gone through if I've at least breezed through all of the filings that are on the Fairfax County website, and I've read in depth, the opinion letters by the judge for the motion to dismiss. I've read, the motions for summary judgment, like that kind of stuff. I kind of skipped past a lot of motions to compel discovery partly because there are just so many of those. And I will say that, like when we're talking about civil litigation and the discovery process, courts usually are hands off for any kind of discovery process for most cases because they are busy enough as it is. They don't like to get involved. They don't like to be pulled into disputes. So at least my experience has always been in California is that there are specific rules in any jurisdiction, really, whether we're talking federal or state court. There are specific rules for how much time you have to respond to a discovery request, or what kinds of requests and how much you can request, and what kind of questions are legitimate, can be asked, are entitled to a response, or what kind of questions are improper, and you can just say, sorry, I'm not going to answer that because you don't get to know that. There's all kinds of rules. So all of that stuff is sort of enforced with one another, basically by keeping a paper trail of your correspondences, by saying like, you were served with this, you have a certain amount of days. If you can't make that deadline by a certain date, then we meet and confer. You can ask for an extension. Usually that's going to be granted because no one wants to be that a-hole. Because everybody needs an extension at some point, in their work life. But when you get into, so you get responses back from somebody and they've objected to the response, or to the question, and they haven't given any kind of a response. Then you say, okay, we need to talk about this because I am entitled to a response. And then you kind of go back and forth. It's called the meet and confer process.
Right.
Courts always want you to go through that before you try to drag the court into it. They want to know that you have actually tried to work this out on your own.
Right.
And so because of that, I have never had to file any kind of a motion to compel. I've never had a motion to compel filed against me or my client because we've always managed to work things out. So the fact that there are, not just any motions to compel, but a lot of motions to compel gives a very good indication of just how much animosity there has been in this litigation.